Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have another busy and full docket for you today. First, there was a hearing regarding Chad Daybell, and we got to view a little update on Lori Vallow. Second, the court has issued some orders for Barry Morphew. Third, Jussie Smollett gets his wish. Then we have an update on the co-conspirator regarding Mr. Alec Murdaugh. That's right. People are starting to be indicted. I expect a lot more. Next on the docket, have you ever heard about Operation March Sadness? Yeah, this will make you a little sad when you hear about this. We have a story about a little sleight of hand that didn't work out so well for one person. We have a dirt bike motorcycle gang in New York City. I know, a little ironic. And then finally, our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. It is Thursday, March 17th, 2022. Welcome to Crime Talk. Now, if you haven't done so already, hit that subscribe button, please. Make sure you hit that little bell so that you receive notifications of when we go live or put up new content. And remember, leave me a comment below. And never forget that you can not only listen to this podcast, but all of our previous podcasts by simply downloading us on any of your favorite podcasting apps. Simply type in Crime Talk with Scott Reich, and bam, there you are. You can get us all the time, anywhere at your disposal. All right, before we open today's docket, let's have a quick word from today's show's sponsor. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. Let's open the docket for March 17th, 2022, St. Patrick's Day. First, an update on the Chad Daybell, Lori Vallow matter. First, let's talk about Chad Daybell. There was a status conference held today, and the court said, we're going forward tomorrow on the motions hearing that is set on March 18th at 9:30 a.m. Mountain Time on the motion to sever the cases between Lori Vallow and Chad Daybell. It's really severed from the same indictment, but you know what I'm saying. And then we have a motion to dismiss the indictment that is set for March 23rd. Still not exactly sure why we can't do this all in this one day, but whatever, at least we're making some progress. Then in regards to the motion to reconsider regarding the transporting the jury and the venue transfer has also been rescheduled, and that new date is April 20th of 2022. And according to the state, they need more time to prepare a briefing that must provide new and updated data. Apparently, maybe their numbers that they provided before weren't as accurate as they might have originally thought, and they want to make sure they don't make any misrepresentations to the court. We'll see. Now, what is the one important thing about today? That's right, Lori Vallow, still not there, still not present. Why? Obviously means one thing. She is still at the state hospital. Nowhere to be found. Just noting that for the record. Next on the docket, let's talk Barry Morphew. The court has issued a couple of orders. First, in regards to Defense Motion 53, the motion for discovery and ongoing full disclosure of any records, materials, or investigations of prospective jurors. Now, as everybody knows, Barry Morphew has been charged with first-degree murder along with several other counts for the alleged murder of his wife, Suzanne Morphew, going back to May 9th or 10th of 2020. Obviously, Mr. Morphew has pled not guilty, and a jury trial is scheduled to commence April 28th, literally just over 5 weeks from now. Well, the defense has filed motions regarding the ongoing discovery that needs to take place. And basically what it boils down to is the prosecution has conceded that the defense is entitled to any information provided by law enforcement to the prosecution, including any criminal history of potential jurors. Now, the people argue that the defendant is not entitled to other materials, reports, notebooks, or other information regarding prospective jurors that the prosecution has obtained or will obtain. The people also assert that material developed internally in the district attorney's office is protected by work product and not discoverable under Rule 16, which is the rules of discovery, which is basically you have to give the defense anything the prosecution generally comes up with. Well, the court says, based upon Rule 16, the people must turn over any material requested unless it falls under the umbrella of work product. Those are the impressions, the thoughts of the attorneys in the work product. That makes sense. Therefore, the court states that to the extent that people are generating criminal histories or compiling data about prospective jurors' prior service, it must be disclosed. That makes sense. That's not within the general purview of the defense, and if they're running criminal histories on prospective jurors, they have to turn that over. Makes complete sense. But the court then states that any issues related to whether materials are considered a work product pursuant to Rule 16, 1E, 1 should be resolved between the parties, and if they can't agree so, then the parties can utilize Rule 16.3 to involve the court. That's a fancy way of saying try to resolve it yourself before you come to the court and waste my busy, valuable time. The next motion was an order regarding defense motion number 47, which is the motion for preservation of jury materials beyond the statutory 3-year period, and defense motion 51, motion to order the jury commissioner, clerk, bailiff, and other court personnel to preserve notes, Excel sheets, emails, logs, and other materials related to the handling of prospective jurors' requests and communications. Well, the court says granted in part, denied in part. The court orders that the following materials must be kept as part of the record. 1, juror questionnaires. That's routine. Notes, questions, and written or electronic communications from prospective and seated jurors after they respond to their jury summons. Written communications from the jury commissioner about the prospective jurors and seated jurors after they respond to their jury summons. The juror list containing the names of the prospective juror summons for this case, a list of the prospective juror who responds to their jury summons, and the summons of the prospective jurors who respond to the courthouse. The court will not expand the jury materials preservation beyond the statutory 3-year period set forth in the statute. Now you may say, why is all this necessary? Well, if there is in fact a conviction, they want to be able to go back and look and see if there was something that, maybe wasn't disclosed. I'm telling you, Barry Morphew has hired a very, very, very competent legal team. They are pulling out all the stops. And, the beautiful thing from the defense perspective is when the prosecution is busy working on all of this busy work, so to speak, guess what they're not doing? Working on preparing for their case. There's your learning point of the day. All right, let's get to the rest of the docket. Jussie Smollett, he wanted to go home. He got his wish. So Mr. Smollett was released last night, just 6 days into his 150-day sentence for felony disorderly conduct. Now, Mr. Smollett, as you may recall, was convicted of 5 counts of felony disorderly conduct in December after a jury found he did in fact lie to the police back in January 2019 and repeatedly since then by claiming that he was attacked by 2 white homophobic Trump supporters back in 2019. Well, last week, after an hour-long sentencing hearing where his attorneys begged the courts not to send Mr. Smollett to jail, Mr. Smollett was sent to the Cook County Jail for 150 days. Now, Mr. Smollett protested the sentencing, screaming that he was not suicidal, and if anything happened to him, he was obviously knocked off by somebody. Well, since then, Jussie Smollett's family and his legal team have taken to social media to explain why they think Jussie should be able to go home. The family claimed that he was immunocompromised and a high risk of COVID. They claimed that he was being restrained to a bed in the psych ward, and they claimed they were getting threats from people saying they were going to hurt the actor, despite Jussie being on 24-hour watch. Well, Mr. Smollett was released by an appellate court panel so he could contest his conviction. He was freed after he posted the request of a $150,000 personal recognizance bond. Okay, let's just say this is very rare. Normally when somebody goes to trial, they lose, they can appeal. Rarely. I mean, probably maybe 1% of the people get to remain at liberty, and they usually have to post a significant cash or surety bond. Never have I seen in 27 years an appellate bond that was a personal recognizance bond. I'm starting to think that a little bit of Jussie Smollett privilege is coming through here. As you may recall, Mr. Smollett had some pretty powerful friends that basically made this case disappear early on. It seems like maybe that Jussie Smollett privilege may be coming back. Anyway, appellate justices Thomas Hoffman and Joy Cunningham were the two judges who approved of Smollett's release, saying the defendant has been convicted of non-violent offenses and that this court will be unable to dispose of the instant appeal before the defendant would have served his entire sentence of incarceration. It is thereby ordered that the motion by the defendant, Jussie Smollett, to stay, which means to stop his sentence of incarceration, and to grant him a bond pending the disposition of the appeal or until further order of this court is granted. A third judge, Maureen Connors, disagreed, writing, "I dissent," and would deny the motion. Mr. Smollett's attorneys said that he had been refusing food during his stint in jail, ice water that had been his food and only liquid. His attorney stated, "I can only imagine if I was in jail for something I didn't do, I wouldn't be eating either." So apparently Mr. Smollett was engaging in a hunger strike. Well, either way, the attorneys claim that the trial and the judge have politicized everything related to Mr. Smollett, and they need to look out for their client and obviously the public interest. They stated there's no room for politics in the court system, and our appellate courts do not play politics. The attorneys also criticized Chicago for apparently trying Mr. Smollett twice for his crime, saying that his client had already paid the $10,000 and did the community service before the trial. And basically, the appellate courts are hopefully going to get it correct this time around for Mr. Smollett. We'll see. It's Chicago. I'm sure Mr. Smollett is going to walk on this completely, but we'll just have to wait and see. I guess I'm just getting more cynical as the older I get. Next on the docket, an update on the Alec Murdaugh matter as well as his co-defendant. First, in a memo filed in the United States District Court this week, the attorneys representing Alvin Glenn Detention Center rebuked the word of the attorneys representing Mr. Murdaugh. As you may recall, the attorneys that are representing Mr. Murdaugh had filed a case in the United States District Court in South Carolina stating that the telephone calls made by Mr. Murdaugh while he was in custody, where he was advised of the fact that his calls were being recorded, should not be released. And I'm sure they're doing that because they are damning to their client. There's no doubt in my mind. Why would you go to such expense and time to do that unless there was something really, really bad there? So while Mr. Murdaugh has been held at the detention center on that $7 million bond, he's been talking on the phone. There's been 5 judges who had to be reassigned because of an alleged conflict in regards to their connection with Mr. Murdaugh. Now, the attorney for the detention center, a gentleman by the name of Mr. Lindman, an attorney by the name of Mr. Lindman, added that the 2 lawyers for Mr. Murdaugh have not presented any evidence nor any legal justification for the extraordinary relief of a preliminary injunction, and as such cannot show a likelihood of success on the merits of their claim for injunctive relief. And that is the legal standard for a injunction. Mr. Lindman noted plaintiffs have woefully failed to demonstrate a likelihood of success on the merits. Lindman points out how their client, in addition to being explicitly advised that each call was being monitored and recorded, should have known the Freedom of Information Act provision applied to his conversations. Mr. Murdaugh himself is a trained lawyer and should be very familiar with FOIA and its broad application under the South Carolina law. We'll have to wait and see how the court's going to rule on that, but my thinking is that we're going to get to see and hear more jailhouse calls from Mr. Murdaugh. Well, the co-defendant with Mr. Murdaugh, a gentleman by the name of Mr. Corey Fleming, he appeared before Judge Allison Lee, and Judge Lee set bond this morning at $100,000 surety bond with the ability to pay 10% for Mr. Fleming, the alleged co-conspirator with Mr. Murdaugh and his alleged financial crimes. Fleming is reportedly Murdaugh's closest friend and Buster Murdaugh's godfather. He was indicted last week on 18 counts for his alleged role in the theft of $4.3 million from the Satterfield family. Now, prosecutor Creighton Waters from the South Carolina Attorney General's office apparently made Judge Lee aware of Fleming's financial situation, saying that Fleming was facing severe financial problems and had very little money in his account. Waters also said that Fleming has not in any way cooperated with this investigation, but Waters was careful to point out that Corey Fleming and Alex Murdaugh are two different people. Eric Bland, an attorney for the Satterfield family, said that Corey Fleming is a personal embarrassment to our profession. Mr. Fleming attended the hearing via live feed from the Alvin S. Glenn Detention Center in Columbia, where he was booked early yesterday morning. Deborah Barbier, Fleming's attorney, argued that her client deserved a personal recognizance bond, citing that Mr. Fleming is in no way a flight risk. He's in absolutely no danger to the community, and he has zero criminal history. She also cited that he had been a resident of South Carolina for most of his life, and he grew up in Georgia. He was educated in South Carolina. He got married in South Carolina. He's raised his family in South Carolina, and he's practiced law here for approximately 28 years in South Carolina. Waters asked for a bond of $25,000 per felony charge, which would have amounted to $450,000, as well as all the standard conditions, such as relinquishing his passport and being barred from leaving the state. Mr. Fleming must surrender his passport to the state and is barred from leaving South Carolina without express permission from the court. Somehow I think he will be rolling on Mr. Murdaugh any day now. Okay, have you heard of Operation March Sadness? Well, this will bring a little sadness to your heart when you hear about this. Authorities have arrested 108 people, including alleged child sexual predators and those seeking prostitutes, in a 6-day undercover human trafficking operation in Florida. Among those taken into custody were 4 Disney employees and a retired judge. You see why I don't get really impressed with titles? Because a retired judge, for goodness sakes, gets picked up on a sex trafficking crime. It just shows you it can happen to anybody because we're all flawed human individuals. Bottom line, your title doesn't make you any better than anybody else. During the operation, which was called Operation March Sadness 2, detectives found prostitutes who had posted online advertisements through various websites and social media platforms to identify people who were seeking them out. They also identified adults who they thought were inappropriately communicating with children. Now, undercover detectives then communicated online with the suspects before meeting them at a location and ultimately arresting them. Now, the officers identified 4 Disney employees as among those arrested. Xavier Jackson, 27, worked at a lifeguard at the Polynesian Resort for Walt Disney. Judge said Jackson sent inappropriate photos of himself and a message to an undercover detective who pretended to be a 14-year-old girl. He was charged with 3 counts of transmitting harmful material to a minor and 1 count of unlawful communication. The 3 other Disney employees were identified by Polk County Sheriff Grady Judge as Wilkinson Fidel, 24, who worked at the Cosmic Restaurant at Walt Disney Resort's Tomorrowland for the last 4 years, Shubham Malave, who is here on a visa from India and worked as a software developer for Disney, and Ralph Lees, 45, who spent nearly 4 years working in IT for Disney. Disney confirmed that Lees, Fidel, Jackson have been placed on unpaid administrative leave. It added that Malevi is not an employee of the company. Judge said Daniel Peters, 66, told detectives that he used to be a judge in Cook County 4th District Court and a special assistant for legal affairs in the Office of Professional Regulation at the Cook County Sheriff's Office in Illinois. You can't make this stuff up. He was charged with soliciting a prostitute. A judge told him, well, Judge, you need an attorney. You got problems. Yes, he does. Yes, he does. All right, how about a little sleight of hand? Police in Seguin, Texas, a city of around 30,000 people near San Antonio, said that a magician used a sleight of hand quick change trick to take a total of $2,700 from a Walmart cashier on 2 occasions, on January 10th and February 12th. The Seguin Police Department explained the scam in a Facebook post, saying the suspect will count out the change, showing the employee that he was shortchanged while he uses his other hand to pocket a portion of the money. The police also jokingly said they hope the officers would receive a helpful tip about the magician so that they can book him for the next magic performance. The police also provided 2 photos of the suspect from the 2 different incidents. The suspect is still at large, and if anyone has any information regarding, they should contact Detective Schramm at 830-379-2123. You got to be careful, people. Everyone out there, be careful. Next on the docket, New York City. Once again, the New York Police Department released some pretty terrifying surveillance footage of a gang of dirt bikers beating down a 64-year-old motorist and his son in West Harlem. Police say the attack occurred after the man accidentally hit one of the bikers at an intersection after the group had run a red light. Now, the video shows at least 3 bikers and 1 ATV rider ripping the 64-year-old driver from the parked vehicle before throwing him into the street. The gang proceeds to kick the man and go after the 36-year-old son in the passenger seat. The attack took place in broad daylight. That's right, on Tuesday at 4:30 p.m. Now, after beating the victims into submission, the suspects fled the scene. According to the police, they headed west on their bikes on West 127th Street. And according to the department, the suspects swiped a cell phone, credit card, debit card, driver's license, and about $150 before fleeing. So good. They now have charges for aggravated assault as well as aggravated robbery. That is swell. The suspects are still at large. None of the dirt bikes or ATVs had license plates, and because they're not street legal, both victims suffered minor injuries and were taken to a nearby hospital. Police released the footage on Wednesday in hopes that anyone with information about the suspects could be identified. So if you know any of these knuckleheads, let somebody at the NYPD know. And finally, our dumb criminal of the day. Please meet Antonio Stanley. He is a 40-year-old Cincinnati resident and was busted on felony trafficking and possession counts after he was pulled over on Interstate I-75. Police found a large amount of marijuana, THC wax, and an individually wrapped Freestone pickle in his car during a traffic stop. According to the Bangor, Michigan-based Freestone Pickle Company, its products are a great salty snack alternative that are low in calories and fat and cholesterol. The confiscated pickle had an estimated street value of about $1. Can't make this stuff up, ladies and gentlemen. A pickle. All right. Thanks for watching. We'll see you next time on Crime Talk.